Hey,
What's going on, everyone?
how are you guys?
Fan freaking tastic. How about you, Erica? What's happening in your little slice of heaven?
Oh my goodness, this is so fun. So, I shared my very best attempt at my first lawsuit with everyone, and it got absolutely ripped to shreds. Thanks, everybody who
That was
gave
awesome.
feedback. Seriously, I loved it. Because I think that the main thing that it told me was how much I don't know. And
Mm-hmm.
that's great because now I put a plan together to start realizing I need to, I'm one of those people where I have to have a big picture concept before I can start understanding all the little teeny tiny details. And I was operating in teeny tiny details, trying to piece things together. So I took a step back. I got some books from the library. I got a study buddy who has access to Westlaw and goes to the library, law library every week. And I've got a couple of other friends. We're working together on stuff to understand big concept things that I was missing. And so I'm just kind of regrouping, and that's okay. And that's what I wanted to offer encouragement about to anybody who is putting together their best. And then it's just not even close to right. That's okay. Like, that's what we're here helping each other to do. So,
Yep.
and we're learning along the way. So be patient with yourself and be patient with others. For those of you who are helpful enough out there to give us the feedback, thank you when it's constructive, when
Yes.
we can actually do something about it. That's really, really helpful.
It's a good point. It's a good point. We don't know everything, right? So
Right.
awesome. Well, thanks, Erica. Yeah, real quick for everybody that's just joining us here. I am James Patriot. This is the Justice Revolution. I'm your host. I'm here with my co-host Erica in South Indiana, and producer and other co-host Justice. She's actually, Justice is not too far away from where I live here in Utah. So we appreciate you guys joining, and I know there's I believe there's quite a few that are jumping over from the interview that I just did with the one and the only Beth Martins from King's Hero Journey. So welcome if you're here. I know we've our Telegram chat has just been exploding, so it's good. It's great. I love to see it. So
Yeah, cool.
so today's episode is a follow-up from what we've been talking about for the past couple of weeks. We've been talking about writing a lawsuit from scratch. So Erica has been working on hers, and I'll let her share her story here just to give a refresher here in a second. And then when she's done with that, I want to go over two things. There has been a big, I don't know what's the word I'm looking for, hubbub, to do, whatever you want to call it. A case has hit the Supreme Court docket that people think is just going to save us all. Let's just put it that way.
Oh, yeah.
So I want to talk about that case. And then I want to talk about what I did with my local school district case and where we are with that. So Erica, do you want to give us an update on your situation, where you are? And you did a little bit there in the introduction, but fill us in on where you are now.
So I was fired from a hospital network system after 19 years of successfully working there and being one of their favorite employees, with all of the garbage that went on. And I was refusing to wear a mask because your body really needs this thing called oxygen
Yeah, isn't that weird?
to be healthy. And so I didn't think that that was right. That's what started me on this whole thing. I have zero background in law. I'm just like everybody else who was never taught anything. I was in public school, never learned anything about civics, or I took government and econ my senior year of high school, I think. But we watched a lot of movies and played a lot of euchre because that's what we do in Indiana.
Yeah.
So I know nothing. And so, but I knew in my spirit that something was very wrong, that they should not have been able to do that for me, because to rob me of my livelihood and my ability to provide for my children just because I didn't want to harm my body. And so that kind of set me on this course of trying to figure out why is that wrong? And what recourse do I have to call it out as wrong? And so those are the big questions that the lawsuit has been walking me through. And it's really like building the airplane while you're flying it, because I'm trying to put together information while I'm learning it. And so, I miss really big things, like understanding things like the difference between an Article 1 court and an Article 3 court. I didn't even know there were two different kinds of courts like that. And, just big types of questions, like even how did we even get to this point? Like that we've got statutory law and the Constitution, like it doesn't apply to me. It's rules for our government who are supposed to just do one thing, protect our rights. Big concepts like that the general public just doesn't even know or understand. And I am among those people. So I've just dug in for the last year and have made a really very serious study. And it's all so new that it's hard to put together a complaint while you're still learning what the rules of everything are. So that's where I am. Like I said, I put my very best attempt together and everything was wrong about it, but that's okay. Everything was, and it's fine.
You're 10 steps ahead of me because I have never written a lawsuit. So you've got someone who's never written a lawsuit. You've got someone who's written one lawsuit, and then James who's written many. And that's okay because, there's always someone there to help you. And, I haven't even made an attempt yet because I would be afraid to put mine on Telegram.
Well, once you get in it, you realize you're in it for the long haul.
Yeah.
I mean, it's not just hey, I'm going to submit this and then they're going to decide on it right away. It's like lots of emails back and forth about you need to amend this and this isn't quite right. Why don't you, just all the little tiny rules that you find out along the way. And so thankfully we've got a lot of people in these groups who know all those little teeny tiny rules that I have no idea of. And so it's really helpful when you share it. And then I can be like, oh, okay, now I even know that exists. Like, how can you try to do it right when you don't even know what to ask about if it's right, because you don't even know it's a thing. So like jurisdiction stuff, that's another thing. I was like, what even is jurisdiction? Just starting out. So the Dr. Graves course really, really helped. And I was telling the big Sib the other day, I was like, I'm doing it again. And he's like, I've done it like 6 times, because you just have to keep, it once is not enough. Like,
you hold on a second. You didn't do Brandon's. You got to give. I did it like 6 times. You got to get Brandon's accent right there.
Oh, okay. I haven't heard him talk. We've only.
Oh, you haven't? Oh, geez.
In writing, no.
He's got a sultry voice. If you're tired or if you're like having trouble sleeping, he could read you a story. You'll be out like that.
Yeah. Yeah. With the southern twang.
I love the man. As a matter of fact, I actually called him earlier today. We had a conversation, so he wouldn't have any problem with me sharing that. But
yeah, I'm realizing stuff that like people don't even know about. I didn't have any idea that there was this thing about being in the private and then being in the public and all of everything. Like, it's all so much and so big. And I could read every day for the rest of my life and still not even come close to knowing all that's out there to know. So the more I know, the less I know. And that's kind of frustrating, but I'm just doing my best. I'm working along with a bunch of other people who are waking up and who are trying to just figure it out. I'm just doing my best. I am, that's all I can do, right? Because I'm also homeschooling my child, which is kind of fun because I've combined his learning with my learning.
That's good.
I was telling you guys a little bit about that. I've got him interpreting for kids the Federalist Papers. And so we're going line by line together with every letter and putting it in kid language. And that's been really fun. But just I want to give him a chance to get the education that we never got. This is like secret knowledge because then they can keep you in slave mode and keep profiting off of you and keep you just dink, dink, dink. What's next? Oh, I have to do that now. Oh, okay. I have to do that now. No, we don't have to do any of it.
Mhm.
Like, we're
Yep.
private people and we can do what we want as long as we're not hurting anyone else.
Yep.
So
No,
figuring that out and walking in that and knowing how to stand in that and learning all the stuff that you need to back it up, it's a major, major process and it's a commitment. But we're called to do that.
Yeah.
We can't keep bending over to a corrupt government that would rather us be their slaves. That's what we ran away from in the first place, right?
Exactly. Great point. Good stuff. Yeah, and I think, because you have a direction to go now, right? Because if memory serves, you took a look at, or you're modeling your suit off of the one that the big Sib just wrote for his daughter, Brandy. Is that right?
Yes.
Similar.
There are components of it. I'm really struggling with this idea of, because so much of it is so new. This is a new situation where, honestly, in general, I was looked at as a person who was being selfish and potentially harming other people because I was choosing not to cover my face for my health. And so, like, there's a lot of difficult conversations in this that I have to go about it, where I'm figuring out, I know that something is wrong, but I have to give it the name that the law calls it so that I can complain to show that they're not in compliance with what needed to have been done.
Yeah.
And so I'm still trying to iron out that big piece of it.
Yeah. Yeah. I mean, this is what I hope, if any of you that are watching, we're just watching the Beth's interview, and any of you guys who haven't and have watched or listened to our past podcasts, is that this is a big learning curve. I mean, it's not something you can learn overnight. The good news is you're not alone. We've got quite a few people that are willing to help. You've got two fantastic individuals here, Erica and Justice, that are nose diving into the deep end on this. I mean, Justice has got a case that she's pushing through federal court right now. Erica is getting hers ready to go. I've got 4 other cases that I'm litigating. So yeah, I mean, it's a process, but what I hope, my hope is with this podcast, is with what we do these things for, is that you people that are watching or are listening, please know that you can do this. Okay. Don't think that you're inadequate because you don't have a degree. You don't have, you're not well versed in the law. You only need 2 things. Number 1, the ability to read, and number 2, the ability to write. And thankfully we have computers. We have all these sorts of things we can do now. I've told you guys this before. I'm not smart enough to sit down and write a lawsuit from scratch. We talked about that in our last episode. What's my process? What do I do to find what I'm looking for? And I apologize, my kids are having an argument in the hallway there. So
technology, it's a great thing. James, would you review the 3 steps we went over last week?
Yeah,
if you
I
wouldn't mind.
remember what they were.
And well, it goes along with that. I think it was, finding a suitable case. Oh
yes, yeah. So I mean, so really, you got to look at it. Go, okay, what happened? Who did what to whom? And once you have that understanding there, you can start doing some research. Telegram is the best place to start. You can jump into, obviously to our group, and Affidavits 101. You can jump into Brandon's group, the Big Civil Law. Randy's group, which is the Law Society and the Mask Society. He actually has 2 channels. Just start searching and researching and say, hey, this is what happened. Does anybody have a suggestion for a cause of action? If you're unaware of what a cause of action is or what a cause of action you can take, you need to refer back to Dr. Graves' course, How to Win in Court. He doesn't list all the causes of action, but he lists quite a few of them. I don't remember how many are there, Erica. I don't remember if you know, but there's quite a few.
There's a lot.
Yeah.
None of them really applied to my case specifically, which was kind of sad. But it's enough that it gives you an idea of following the essential elements of a cause of action to be able to prove your case. That's what it was helpful for me.
Yep. So there's the website there, howtowinincourt.com. So that's the first thing to do. Start researching. What I do is I jump onto Google and I just search sample lawsuit for, let's say, it's a civil rights complaint. So the most common cause of action that I pursue is Title 42, 1983. This is the statute. This is the law that gives everyone the right to sue for constitutional right violations. I mean, you could sue anyway, but Congress wanted to take it a step further and said, all right, if a government worker from the state is acting under the color of law, they're making you believe that this is what the law is, when in reality it's not, because your rights trump the law. You have a cause of action there. And when you read that, it gives you what the essential elements are, just reading the statute. So jump onto Google, do some research, find some sample lawsuits. We talked about this last time. There's a law library that one of Steve Emerson's friends has put together. It's not cheap. It's about $500 to get that, but it also has a full, complete copy of American jurisprudence. That's crucial. I subscribe to Westlaw, so I can get access to that because I want to make sure I'm up to date on things. And once you have those things, then it's just start copying and paste. This is why I put everything that I do into the chat. So if what I'm doing will help you, copy it, paste it. I've said this before. I'll say it again. Plagiarism is not only allowed, it's encouraged.
Right.
And Randy says this all the time. Imitation is the highest form of flattery. It really is.
Right.
So if somebody takes a suit that I've written and all they do is change their names and turn it in, then hey, I'm flattered. So that's the process. That's how you start there. So to piggyback on where we are from last week, I want to talk about amendments. What happens when you need to amend a lawsuit? But before I get to that, let's talk about this Supreme Court case that everybody's all hubbubbed about. Did you guys see anything about this real quick? You know the one I'm talking about?
With Joe Biden?
Yeah, there was. I was sent a text message, and then I got messaged on Telegram about it from Alina, our good friend. Mm-hmm. Here's what's interesting is I'm going to share my screen so you guys can see this, because this is what is interesting. Okay, so here's Alina sent this to me. She says, "Hey, can you open this docket? This guy here, I don't know if you guys can see this. It's kind of small. There we go.
Let me get it in."
So this guy, his name is Lloyd Brunson. He authored a lawsuit against Joe Biden and like 300 something individuals of Congress.
Right.
This is in his paperwork to the Supreme Court. He says respondents were properly warned and were requested to make an investigation into a highly covert, swift, and powerful enemy, as stated below, seeking to destroy the Constitution of the United States. Basically, what he was bringing is that they violated his inherent and sacred right to vote. Okay, so this was docketed with the Supreme Court. Now, full disclosure, when I clicked on this link, it opened it before, but look now. I don't know if actually I think I have to change my share settings here. So let me go back here.
So I'm going to give the first 3 steps real quick while you're.
Okay.
The first one was you've got to subscribe to howtowinincourt.com.
Howtowinincourt.com. Step number 1.
Step number 2 is research cases related to your situation.
Correct.
Your case. And step number 3 is start writing your
draft. And then once you get your draft written, post it in a Telegram chat somewhere, just like Erica did. So
and then step number 4, start all over again.
That's right.
Step number 4, get a box of Kleenexes for all of you who don't have tough skin like me. In nursing, they eat their young, so I'm already used to it. Okay, let's just go there. But if someone calls you an idiot or tells you don't know anything, just be like, you're right. I have no idea what I'm doing. That's why I'm here. Thanks for your help.
Yeah. So going back to this Supreme Court thing, that link that I showed you there in the Telegram group, this is what it shows. A blank page.
Huh.
Even if I hit refresh, it's blank. This link was working yesterday. So the only thing that leads me to believe is that the Supreme Court has said, no, we're not going to look at this case. So I have no idea. But I did find right here. So this is what's interesting is this is the case named Brunson v. Adams. He originally, from my understanding, filed this in the state court. And then the defendants had it removed to federal court, which is the district court here. So here's the case number. And if I wanted to, I could go look up the complaint, but I really don't want to because and I'll tell you why. It's don't get me wrong. I love that he took this action. I love that he did this, but it was dead in the water from day one. And when you read what the
why is that?
Judge, and I'll tell you, this is why.
Okay.
So let's say right here, when you read what the district judge had to say, you'll understand why. She says, the district judge referred this case to Magistrate Judge Jared C. Bennett. Before the court is defendant's motion to dismiss this action for lack of subject matter jurisdiction. Okay? So remember that. Or in the alternative, to dismiss for failure to state a claim. For the reasons set forth below, the court respectfully recommends that this action be dismissed for lack of subject matter jurisdiction. Okay? Erica, do you remember what subject matter jurisdiction is from jurisdictionary?
The ability to have the the authority to rule on the topic that you're bringing before the court.
There you go. Yeah. So there's a number of things that the court must have in order to establish subject matter jurisdiction. So one of those things is standing. You must have standing. So it's called Article 3 standing. And Article 3 is referring to Article 3 of the federal Constitution. And what that is that you have to be able to allege and prove that you suffered personally. So let me give you a good example. So if I was to fly to Indiana, knock on Erica's door, and punch her in the face, she would have standing to bring a claim against me for violating her rights to be free in her own person, right?
Right.
Because she can allege and prove that I punched her in the face. Now, the difference is what happens if I say that I'm going to do that, but then I never do, but then Erica brings a case against me and says, well, he said he was going to punch me in the face, and because he never did, but I felt like he did, and so I'm going to sue him anyway. Does she have Article 3 standing based on that example?
No, you
don't. Okay. In this complaint from this Mr. Brunson, and I don't know who this guy is. Apparently, he actually lives not too far from me. But I don't know who he is. I've never met him. When I was talking with Alina earlier this morning, she said she did meet him, and he seems to be like a pretty nice enough guy. But the issue with this is that, as you guys can read here, he says the presidential election was rigged and fraudulent prior to accepting the electoral votes. According to Mr. Brunson, the plenary power of the 9th Amendment nullifies any interpretation of the 12th Amendment that would allow Congress to accept and count fraudulent votes. Mr. Brunson asserts that defendants' conduct constituted an attack against the U.S. Constitution that resulted in the fraudulent inauguration of President Biden and Vice President Harris. I'm not saying that I disagree with that, but just this is what the court said, okay?
Is this a pro se?
Yes. Yep, he was acting, it says right here, appearing pro se.
Okay.
Yep. Okay. So then as you move on, he stated 6 causes of action. Okay, here's that word again. 6 causes of action. Promissory estoppel. This is a cause of action based on defendants' failure to fulfill their respective oaths of office to ensure an honest and fair election. promissory estoppel for giving aid and comfort to those who sought to wrongfully invalidate Mr. Brunson's vote, breach of duty, intentional infliction of emotional distress, fraud based on defendant's misrepresentations, and civil conspiracy. So the issue that he has is everything past this first cause of action, he is unable to prove he has standing for. Does that make sense?
Yes. Could you define estoppel for everyone, please?
Yeah. So estoppel is just like it sounds. Promissory estoppel means you cannot do this. You're stopped from doing it because you made an oath. So promissory estoppel is I promise that I will never do this. And if you do, then you've violated promissory estoppel. I don't know. I hope that makes sense.
Yeah, it does.
Okay.
I like to point those things out because I struggle with the legalese stuff.
Yeah. Yeah.
And that's where I like to, because I know there's, like we always talk about, there's always somebody new every single day that's just waking up or getting involved in these things going on. So
yeah. So
do you understand this question? I'm not quite sure what he's
I
asking.
totally understand it. Is
I'm
rigged?
sorry,
Is this hearsay?
Is it hearsay? Is that what?
Yes.
Rigged? Is this hearsay? Yeah. I mean, it's not hearsay per se. I mean, it's someone's opinion.
It's conclusory. That's the problem that
you're making a conclusion.
You're making a conclusion. You can't just say that it was rigged. You have to just make statements that lead the reader to conclude
there you go.
It's rigged.
Oh,
and that's another one of those big pictures. Good catch, Chris.
Oh.
About, you just think you're writing the facts as you see them, but someone with a good eye will read it and be like, yeah, I could dismiss this because they're, you think you're doing a great job getting the facts all together, and it's like it's all opinion and conclusory.
Yeah. Oh, the student has become the master. Erica, you're learning so much.
Only because I'm doing so many things wrong.
That's how you learn.
Yeah, it's true.
Right? What's the famous quote, Edison? He didn't fail 2,000 times. He learned 2,000 ways not to make a light bulb. Right?
There you go.
Right.
Yeah, but he never gave up. Right? Never gave up.
Or 10,000. I think it was 10,000.
It's something like that.
Yeah.
So here's some other issues with this. Excuse me. Again, he alleges that the defendant's conduct has damaged him to the extent of $484 million for each, for a total of $2.9 billion, which he requests be provided tax-free.
Hey, if Alex Jones has to pay, we can certainly get Joe Biden to pay. Why not?
Yeah, let's do it. So what I want everyone to know is, while I applaud Mr. Brunson for taking this action, this action was dead in the water from day one, because and ultimately what the court said is he lacked the standing to bring such claims because he could not prove beyond a reasonable doubt, and not beyond a reasonable doubt, excuse me, that's the criminal standard. He cannot prove with a preponderance of evidence that he was the only one that would have suffered from this. Because look at it this way. If he's making these claims that their actions caused him this much damage, what's to say that didn't happen to me or to Erica?
Right.
Or to Justice or to anybody else for that matter, right? And that's essentially what the court came back with. Here's the discussion. Because the jurisdiction of the federal courts is limited, there is a presumption against our jurisdiction, and the party invoking jurisdiction bears the burden of proof. Oh my gosh, can you believe that? So this is in federal jurisdiction, but what about those pesky state courts? Same thing. To establish jurisdiction, the asserting party must allege in its pleading the facts essential to show jurisdiction and must support those facts by competent proof. Applying these principles, the court finds that Mr. Brunson's claim should be dismissed because he cannot satisfy his burden to show that subject matter jurisdiction exists. Specifically, Mr. Brunson has failed to 1, establish Article 3 or prudential standing, and 2, that the United States has waived its sovereign immunity for any of his causes of action. So that is what the district court said. I looked up, he appealed it to the Appeals Court of Appeals. I looked up what the appeal court judges wrote. They said the same thing. And that's why I'm speculating at this point, because I can't find anything, but that's why I believe that that Supreme Court case, it was docketed and it said that the court had until the 23rd. I'm thinking they probably took a look at it and said, yeah, we're not going to hear this. So, because the court doesn't have standing. I mean, the court doesn't have jurisdiction. So for those of you who are wondering, can courts operate without jurisdiction? Well, sure they can, and they do, but it renders any one of their judgments void. And these federal courts want nothing to do with stuff like that. The last thing they want to do is overturn one of their judgments. So that's my thoughts on that. I know that there are some people at Justice can attest to this. Last night there was a very heated debate in our Telegram group. Some people were very excited about this, and I'm just like, I wanted to talk about it because while I applaud him, your better use of your time is to fight the local battles, fight the battles you can win. Do like what Erica's doing, going after her former employer. Do what I'm doing, go after local officials who have violated my rights, particularly my kids' rights. Do what Justice is doing, go after corrupt organizations that are trying to violate her rights. This is where we make a big change, is by getting this, looking at the big picture, going, okay, am I gonna take down the head of the monster? Man, I would love to, but it's not going to happen. So why don't I start at the bottom and work my way up?
Right.
That's the approach to take.
Right. And it's, numerous large personalities have been saying that for years, is it's local action makes national impact.
Yeah.
And that's the truth.
Yeah. General Flynn has said that multiple times.
Right. That's who I was talking about.
Yep.
Throwing around names on YouTube now gets you shut down. So I try not to say
it does? Gee, I don't even know what.
Oh.
Man, I don't even know. Should I be covering my face? I mean, what am I supposed to do now? I don't even know.
So over on our podcast, we literally got a strike last week for a year-old broadcast. A year old. And it was huge.
Ridiculous.
It was step 1 and 2 for how to write an affidavit. We were talking about violations of this and how to. So they found it and they gave us a strike on that. So anyway,
wow.
My computer keeps shifting. So if I disappear, just know
you're good.
I'll come back as soon as possible. But so Alphonse has mentioned it. He mentioned it again last night. So maybe we can either talk about that or do an episode on it. And I asked him if he would like to, but how to do. He said the most important thing Steve Emerson talks about is keeping people away from you and keeping them away from your property.
Yes.
And that's what you were just saying is, your first rung around you is where you need to start instead of skipping over 8 rungs, right?
Mm-hmm.
So,
I mean, and we will do, a future podcast on this. There's so many things, guys, that you have to learn and that we have to learn to do to, get the greedy fingers of the government out of your pockets.
Right. And right now it's writing lawsuits.
Yeah. It's writing things down. It's serving people lawsuits, making them accountable, making them answer you. So all of those things are important to cover, and we will. I mean, gosh, there's so much to do, and we just don't have a lot of time to do it in. I would love to just sit down and do this for 4 or 5 hours straight, but obviously we can't. So this is why we do it. So,
well, why don't we go to sticking to? I think it really makes sense when we stick to steps, and we did 1, 2, and 3. So what would the next? So step 1 is educate yourself, right, James?
Yes.
And everybody advocates for Dr. Graves' course, How to Win in Court. So if you missed us last week, go ahead and subscribe to that. howtowinincourt.com. Number 2, research your case. Do some reading. Learn about what's happening to other people. And then number 3 is start writing your lawsuit based on what James talked about in the beginning of this broadcast, which is find a lawsuit to plagiarize, and not in the sense of where we really mean actual plagiarize, but borrow the code, borrow the.
Use it as a template. Use it as a workflow template. Yes.
Right. And then post and ask questions in Telegram.
Yes.
And if for those folks who possibly did that or who were with us last week and they're on to the next step, right? So technically, Erica's on to the next step. She took the advice and instead of amending her lawsuit, she's actually going to rewrite it completely. Some people would just want to amend it or correct it. So in your opinion, what would step 4, 5, and 6 be as we go through the rest of this broadcast?
So where Erica is she hasn't technically filed her lawsuit yet, right? So she hasn't filed her suit with the federal court. She hasn't served the lawsuit on the defendants. If memory serves, Erica, didn't you remove some defendants too?
Yeah, because that's a whole other thing that I'm considering doing too, because some of the feedback I got was to make the connection of the state nexus, which I still have to figure out what those words actually mean.
It's the nexus test.
In connecting, because the hospital was following the direction of the CDC, the Indiana State Department of Health, the governor's executive orders. And so I'm looking at completely revamping who the defendants are in my case in that regard, because then that becomes a whole different animal of trying to figure out who's actually responsible and under the color of law. And then I have to connect it to what the law was and who was handing it down. And, it just.
Well, do you want me to show you what the nexus test is? What the how it works?
Yeah.
Okay.
So technically, Erica's at step 3.
Yeah.
Okay.
She's still at step 3, right? So she still needs to understand, how to fine tune her suit. Okay. So, Justice, this might actually look familiar, but
this is mine.
Yeah, this is yours. Okay, because we had the same thing in hers, right? So we had to show that there is a nexus. So this is from the 10th Circuit Court of Appeals, and this is what they say. A private entity can be treated as a state actor acting under color of law under certain circumstances. The 10th Circuit has used 4 tests to determine if a private entity is subject to liability under Section 1983 as a state actor. The nexus test, which is what you're talking about, Erica, the symbiotic relationship test, the joint action test, and the public function. So the nexus test requires a close connection between the government and the challenged conduct and generally makes the state liable for a private individual's conduct only when the state has exercised coercive power or has provided such significant encouragement, either overt or covert, that the choice must in law be deemed to be that of the state. Now, I would dare say that every single unconstitutional mandate that came from the state public health departments, from the governor's offices, that absolutely fits.
Absolutely.
Okay. So in your case, all you have to show is that affirmative link. And you're going to see when I bring up my amended complaint how I do just that. Now, mind you, I'm suing public officials that are part of state government because they're part of a school district. Okay, that's what the nexus text is. The symbiotic relationship looks at whether the state has so far insinuated itself into a position of interdependence with a private party that it must be recognized as a joint participant in the challenged activity. So that's what the symbiotic relationship test is. The joint action test requires the court to examine whether state officials and private parties have acted in concert in effecting a particular deprivation of constitutional rights. That right there is what I was going for with this reply for justice. Okay. And then finally, the public function test determines whether the challenged action is a function traditionally exclusively reserved to the state. Okay. So.
And this lawsuit is dedicated to a mortgage company. And I know there's a lot of people out there. So hopefully we can do a broadcast dedicated to that because Erica is also involved with the same type thing. So, and I know many people out there are. So just so you know what that's about. We do have a couple questions in here. Just let me know.
Let's get to those real quick and then we'll move on.
So here's the first one.
Absolutely. Yes.
Okay.
I'm assuming that's CC. Yes.
Yeah.
Pro se can. Yes. As a matter of fact, here, let me just pull up, because technically my amended complaint is a class action. Whoops, that's the wrong one. That's not the one out.
Were there laws or just guidelines, like with the hospital requiring me to wear a mask?
Yeah, clarify that if you would, CC, if you're still here.
Were there laws or just guidelines? Oh, I'm wondering. I think what she wants to know is did the hospital? I don't know. I guess I'm a little confused on that.
She said yes, Erica, CDC.
Oh no, they were all just recommendations.
Yeah, I don't think any laws were passed
There
nationwide.
was no.
Every
there was no
every
law passed.
email we got said, according to the newest CDC guidelines or the newest CDC recommendations, we're doing this now.
Yep.
Yeah, there was never any official public policy change to the hospital. There was never any informed consent given. There was never any, ability to accept or refuse. They even wanted us to wear our masks walking in from the parking lot so that we could be good models for the community.
Oh goodness.
Modeling for the mask making company, you mean?
Yep.
Yeah.
And people think that they can make laws overnight. There's a whole process. We've got a whole legislative branch, right?
You guys, that was the greatest fear of the founders, was that someone would have way too much power.
Yeah.
And it was set up like this for that very reason.
So laws can't pop up in the middle of a pandemic.
Yes. No, they cannot.
Process. So. They
cannot. And you're going to see here, I'm going to go through this here, and I'm going to do it fairly quickly because I know we're running up on about 45 minutes, and I like to try and keep these to just about an hour.
Okay.
But you're going to see how I tie that in there, how I show the nexus test between the public health order that was issued by this guy, Richard Saunders. Okay. So I'm naming him in this as a defendant in his official capacity, as at the time he was the interim director of the Utah Department of Health. Today he's the director of the health, but I'm only suing him in his official capacity. And I mentioned this on Beth's podcast, but I'll say it again. When you are suing a public official specifically, or even somebody who like in Erica's case where she's suing her former employer, they can be sued in two specific capacities: in their individual as the man or woman that they are, or in their official capacity as, say, the CEO, or in this case, the director of the health, whatever. That's their official capacity.
And that is included in the same lawsuit, right? Not
exactly
separate.
Exactly. So, like, for example, if this guy did something personally to me, then I could sue him individually and in his official capacity. If that makes sense.
And then that becomes a real pain in the butt for everybody, because then the organization lawyers can't cover you all. You all have to get independent lawyers to.
That's something that I found was really funny. Is in another case that we're litigating, we sued these guys in their individual and their official capacity. Well, the Utah Attorney General's office stepped in to defend them, but I found in Utah law that they can't defend them in their individual capacities. And so I pointed that out. Wouldn't you know, lo and behold, we get a notice of appearance of a private attorney. So anyway, so going back to the question, Erica hasn't filed her lawsuit yet, so she doesn't have to amend anything because her lawsuit hasn't been filed. So your next step, once you have your lawsuit written, you're going to file your suit. Typically the process, so everybody's aware, is whoever you're suing, they're going to try and get your case thrown out. And they do that by filing a motion to dismiss. And they're throwing mud up against the wall and hoping it sticks. But this is what I love about our courts, and what I love about the process is there are rules in place that must be followed. So you file your complaint, you serve it on the other parties. Rather than answer your complaint, They just tried to file a pre-answer motion to dismiss, meaning they haven't answered your complaint. They're just asking the court to dismiss it. So you look at it and go, okay, well, then I'm going to go ahead and amend my complaint and make it even better based on the defenses you've given me. So you do that, okay? Now they come back and they throw another motion to dismiss at you. And you're just sitting there going, gosh, is this ever going to end? I've got good news for you people. Yes. Let me show you why. Okay. And then Horizon, you read this book called The UCC Connection. Does not apply to those who lives in the state. Yes and no. So again, Horizon, what I would tell you is whoever's making the claim bears the burden of proof. So if somebody's bringing a claim against you and saying that you're subject to this federal law, I would say, well, what evidence do you have that suggests that I am? Everything retains on evidence. Everything is on evidence. So let me go back here and show you what I was talking about regarding that motion to dismiss. Whoops. Let me get to the wrong screen. Share my screen. Window. Here we go. Okay. Under the rules of civil procedure, Rule 12, which is right here, is what governs defenses and objections, how they're presented, so on and so forth. So if the opposing party presents a motion to dismiss, that's presented under Rule 12B6, failure to state a claim. Okay? If you get one of those and you're going, all right, I'm going to amend my complaint and serve it on you again, and they send you another one of these, well, we need to look a little further in these rules to see if that's allowed, because I'm telling you it's not. Right here under Rule 12G, joining motions 2, limitation on further motions. Except as provided in this rule that's here below, a party that makes a motion under this rule must not make another motion under this rule, raising a defense or objection that was available to the party but admitted from its earlier motion. Does that make sense? So it can get a little confusing sometimes. So when I looked at that, I'm like, okay, well, what have the courts interpreted that to mean? Well, I found this case here. Wells Fargo something company versus South Sioux City. And this was in the District of Nebraska, Northern Court. I'm not going to read all of this here because it kind of gets a little convoluted, but right here is where this is the meat of it. And I posted this in the Telegram chat yesterday. It says right here that this was from the District of Kansas in 2005. A defendant may not raise failure to state a claim after filing an initial 12B motion to dismiss unless that defense is made in the defendant's answer to the complaint, in a motion for judgment on the pleadings, or at trial.
So give us an example, James.
I'll give you a great example. Okay. Let me stop sharing here and go to the next thing. Sorry, I've got all these windows all over the place, and I just want to show people because this is really.
You don't have at least 20 tabs open on your computer. You're not doing your job.
I don't have all that stuff.
Yeah.
So,
okay. He's got 30.
Exactly. Is this the right one?
So yeah. Layman's terms, right?
Yep. Layman's terms. So this. Let me go here to this window, this one here. Okay. This complaint here.
Hold on. Working on it.
Is it coming up?
Coming up. Okay.
There we go. This complaint here, we served our original complaint. They filed a 12B6 motion to dismiss. So I amended the complaint and made it better. Here it is right here. Verified amended complaint. Okay. So I made it. I mean, this is a knockout. This is one of the best lawsuits I've ever written. And I did a lot of this on my own, but I obviously, again, full disclosure, I found another suit and I modeled this after that. Okay. So it's 36 pages long. I'm not going to go through this, but just know we filed this. Well, guess what the defendants did? They filed another motion to dismiss. Okay. So Now what do we do? Well,
What's the
Based on
basis?
what?
they filed another motion to dismiss for failure to state a claim.
Oh, okay.
So they had already filed one of those, and then I filed an amended complaint in response. They did it again.
Okay, for the same thing. Okay.
Exactly. So what I did is I pointed that out in our response.
So what you're saying is they can't, what that rule applies is that they cannot file a motion to dismiss based on the same reason they did it the first time,
Exactly.
but they could do it for a different reason.
Exactly.
Okay.
And let me find where I saved the opposition right here. Here it is. Okay. So we filed with the court an opposition brief. Now, those of you who know Dr. Graves' course, you're going to understand that a moving party files a motion. The opposing party gets a chance to file a reply brief or an opposition, a memorandum in opposition, and then the moving party gets one more chance to file a reply brief. So this is what we replied with. I said, we filed this opposition as a response to their motion to dismiss. The basis for this opposition is defendant's motion is procedurally improper in that the law requires that this dispositive motion be filed under Rule 12C, a motion for judgment on the pleadings after the pleadings have closed, but early enough not to delay trial. A Rule 12C motion is designed to provide a means to dispose of cases when the material facts are not in dispute between the parties. However, as we will outline in the memorandum below, there are still a number of material facts that dispute in this case. Okay, and I won't go through all of this stuff here, but when you go down here to it's improper under Rule 12b-6, this is where I point out that fact is that they filed this again, and according to the rules, right here, it states that in setting out the ways in which a party may raise a failure to state a claim argument after the initial pre-answer motion, it precludes the filing of a second after the initial. Means it can't do it.
Mm-hmm.
Okay. So then I found the Ninth Circuit Court of Appeals ruled that if the court grants their motion to dismiss, that they did so in error. So the court has to treat this as a Rule 12C, which is a motion for judgment on the pleadings. But the rules state that they must file an answer to the complaint first.
Did they do that in my case, James?
They have not.
Okay.
They have not. They filed another motion to dismiss, and we threw it right back in their face. And if the court grants that motion to dismiss, I'm going to file a motion to reconsider and state, hey, this is procedurally improper.
Right. Was it the same reason? I don't remember. It was.
Yeah. They basically threw the same reasons. And what's interesting is, I don't know if you saw this, but yesterday the court issued a denial of their motion to dismiss on the grounds of lack of subject matter jurisdiction.
No, I haven't gone to my email. They did? Thanks for telling me.
Yeah, that was yesterday. Came through yesterday. I was like, woohoo!
James is the man. And we filed for disclosure too, didn't we?
Yeah. Discovery.
Discovery, I meant. Yeah.
Yep. They have said nothing about discovery.
Okay.
So, excuse me. That's where we are. So if you guys ever get to that level, it doesn't matter if you're in federal court or if you're in state court. I have my issues with state court, so I prefer the Fed. That's just me. If you're in federal court, there's plenty of stuff to back you up. You have so much power as an individual. And then let me just real quick, I'll talk about where I'm at with my suit.
And you're amending your suit, right?
Yes.
Or you
we amended it. Yep. And I just I take that back. We filed, if you guys remember, I went over the judge's order where the judge said that these are the causes of action that are not going to work, and these are the causes of action that will. So I took that. I found another lawsuit that I really liked. It was actually I think we talked about it. It was the one that ended the mask mandate for travelers across the country. So what you're looking at here.
Was that Michigan? Where was that?
No, it was in Florida.
Florida.
Mhm.
Wasn't there another one in the northern part of the state? Kathleen talks about it.
There might have been.
I
I'm
think
not
there was.
sure.
Okay.
I'm talking about the one that was in Florida, that in the Middle District, Florida federal court.
Okay.
So, without getting too much in the weeds here, to answer Cece's question, this is a class action suit, and we're all acting as pro se. Okay. What was the failure to state a claim, Etain? There was a number of things that they threw at us. It was all garbage, and it would take a lot of time to try and figure it out. But basically, they said that they were that they were immune. They had qualified immunity. That there was another of other things, and that there was no law that was said that they couldn't do what they did. And I'm just like, you people are dumb. You're just dumb. Basically, it's like I said before, and I'll say it again. If it's not an enumerated power in your state or federal constitutions, they can't do it, period. Just because it doesn't say they can't doesn't mean they can.
Right.
Okay?
And this is where James has so much knowledge, and I'm on the low rung, right? I have a hard time retaining a lot of the legal stuff. Erica does great, right? She's got one lawsuit going. James is helping me with my lawsuit because there's people out there that had the inability to remember this legal stuff. But don't let it stop you. That's why I come on here and try to plead with everyone, because it's overwhelming.
Yeah.
It's definitely overwhelming. But I get in the Telegram chat, I read, I referee, I do whatever I can. But don't stop, because
No.
it's the same thing as what Erica said. She spent so much time writing her lawsuit, and she scrapped the whole thing and she's starting over. Don't let it discourage you, but just keep asking for help. If you don't understand a word, take the time. Like if you hear Steve Emerson talk about it, get yourself your legal dictionaries, take a minute, read it. And if that's all you understand for one day's worth of work, leave it at that.
Yep.
And then pick up tomorrow. Because
Yep.
a year from now, you're going to look back and see how much you've gained, as opposed to standing here a year from now going, crap, I wish I would have done something. So don't be overwhelmed. It's like drinking out of the fire hose, right?
Yep.
I totally get it. That's why I stop and ask all these basic questions, because I know there's other people out there that, like, it starts to strain my brain. I'm like, someone else is feeling it too, right? Just don't let it quit. That's where my encouragement I want to come from. Don't let it, is this coming up, James? Don't let it make you quit, please. Did we take this out, or are you putting this up?
Yeah, no, I wanted this here. Yep.
Okay.
So this is my amended complaint, and really what the purpose of the introduction is to give a brief introduction of what is your suit about, what did the defendants do, and what relief are you entitled to. So I go into the introduction about the jurisprudence of the United States Supreme Court forbids the establishment of a national religion, forbids forced medical treatments, and forbids the exercise of constitutional powers not expressly delegated as enumerated in the United States Constitution and the Utah Constitution. And then I go through, there was 3 Supreme Court cases here.
Now, this is the difference between what the other guy, what you showed at the beginning of the podcast, and now is you've got evidence that you're stating
Exactly
clearly versus the hearsay or the feelings or whatever else, right?
Exactly.
Okay.
Right. So what I'm alleging here, now you're not required to come forward with your proof. You're just required to come forward with your allegations. And what I'm alleging here, I can prove.
Right.
So that's the difference. So again, we want to give the reader what exactly are we looking to doing. Well, this case seeks to protect and vindicate fundamental constitutional rights. It's a civil rights action brought under the First and the 14th Amendments. And we're challenging the defendant's acts, policies, practices, customs, and or procedures which deprived plaintiffs and the consolidated plaintiffs of their right to freedom of religion and the equal protection of the law by discriminating against them because of their viewpoints on the issue of being forced to participate in unwanted and unwarranted religious practices or, in the alternative, medical treatments.
Mm-hmm.
So these acts, policies, procedures also infringe the constitutional rights of other students in the school districts, including plaintiffs, by chilling the exercise of their right to conscience. That's a big one.
Mm-hmm.
Okay. So what I did here, and we want to talk about the nexus, right? We got to connect all of the pieces, and this might be helpful for you, Erica. Is I named a defendant. Oh crap! I forgot to take these people out. Oh, I named a defendant, Richard Saunders, because he issued a mask mandate in the Utah Public Health Order 2020-11. And he did this under the color of state law. He said he could do it pursuant to these codes. But when you look at that, they constitute an unlawful delegation of legislative authority, which we all knew. Okay. Finally, we said we seek a declaration that all the defendants violated their rights, a declaration that the training as set forth violated the Constitution, and a judgment awarding nominal damages for the past loss of plaintiffs' constitutional rights. So then we talk about how jurisdiction is conferred. This is what these are here. You guys can look into that a little bit more. But let me scroll down here and get into the general statement of facts. Again, this is how general statement of facts need to look. It's just like Erica said, you don't want conclusory allegations. You don't want to make conclusions. You want to state what happened, who did it, and when. Well, on this date and time, the governor issued an executive order declaring an emergency due to this. The executive order directs all relevant state agencies to continue the dissemination of timely and accurate information to the public that will slow the spread, prevent unnecessary confusion and alarm, and mitigate impacts to the economy. I don't even know what that means. Do either of you know what it means to slow the spread? Because I have no clue.
No.
Yeah.
Well, theoretically, they're saying, obviously, you know what they're saying. They're saying if you do these things, then less people will get sick and blah, blah, blah.
But
if anybody knows it, it should be Erica.
Yeah, but how do they?
Yeah, you don't want to get me started on that topic.
But that's my question. How in the world can anybody measure that across the state or even the country?
No. And
they can't even prove that it transmits
or exists.
Or exists.
They can't even prove it exists. There you go. Okay.
Or any virus for that matter.
Exactly.
As I'm looking into it, there's a whole nother rabbit hole, people.
There you go. Yeah. There you go.
That's a discussion for another day.
Yeah. And that's a deep rabbit hole.
So here's how I'm tying this all together. Okay. So before the start of that school year, the Department of Health issued the public health order and was signed by the defendant Saunders. The order was issued pursuant to this Utah code without allowing comments under the Administrative Procedures Act.
Oh, there it is.
Yep.
There it is.
The public health order directed all relevant school districts and their agencies to take action to require that masks be worn in all school buildings while on school bus transportation in accordance with the CDC guidelines. Oh, boo. So here's how I tied it together. As a result, the defendants were required to conform to the school reopening requirements template, which is included as an exhibit, which said that students had to wear a mask at all times. So now I'm like, okay, here's the problem. The defendants required that everyone who entered a public school building and everyone on board a school bus to wear at all times and with limited exceptions a face covering that covers the nose and mouth. The practical result was that students were required to wear a mask for hours with very little respite. I'm not sure how you say that correctly.
I think it's respite.
Respite, okay. Except when actively eating or drinking or involved in physical activity. A typical student spent approximately 6 hours in school during this time. And then I go back to this. The adverse health effects of the prolonged mask wearing cannot be casually dismissed. Even healthcare workers who are trained in the use of masks have been susceptible to adverse effects from prolonged mask use during this blah, blah, blah.
Yeah, and there's a lot of 6 hours at least.
And there's a lot of real case study or evidence on that based on the Spanish flu of the bacterial infections from the masks. So that's documented already.
This paragraph that I have right here that I've highlighted, I got that from let's see. It was the effects of prolonged mask use among healthcare professionals. and I included it right here.
Great.
So then I go back and I say among the limited exemptions is that children under the age of 3 are exempt, but they provided no epidemiological basis for this arbitrary cutoff age and offered no discussion of the impact of prolonged mask wearing on children of all ages. By comparison, the WHO, which I am not a fan of, took the position that children ages 5 and under should not have been required to wear a mask, and that the use of masks for children ages 6 to 11 should have been only under limited circumstances. Recent evidence indicates that even short-term mask wearing in children of all ages causes them to incur unacceptably high concentrations of CO2 in their blood. Defendant's selection of age 3 as a cutoff for an age exemption was completely arbitrary. Okay, and I go on. I talk about the emergency use authorization, the Food and Drug Administration hedged their bet on that one as well, because they prohibited manufacturers from labeling their product. Remember?
Mm-hmm.
You can look at those boxes that said, this is not designed to stop the spread of anything.
Mm-hmm. Yeah.
Okay.
So, James, I don't think I ever shared with you. I have a document from a researcher. She's got valid documentation from the 1970s of how masks don't work. So I'm going to share that with you if you can use any of that in this.
Yeah, I might be able to.
Talking about even in surgery, the surgical masks actually up the instance of staph infection.
Yeah. Yeah, that's it. Because, again, it's true. Like right here, I talk about cloth masks.
Yeah.
Because that's what most people and what most kids were wearing.
Right.
I mean, and there was a study in 2015 that concluded that due to the moisture retention, the reuse of cloth masks, and poor filtration, they resulted in an increased risk of infection.
Right.
But they got to have dinosaurs on them, James.
Oh, I know, they were cute, weren't they? Though.
Yeah.
And there was the mask that the state put out that had the state flag symbol on it. I mean, there's all that stuff.
And there was never any kind of biohazard receptacles anywhere for any of this hazardous waste.
The ones that my university provided and my hospital provided were fashion masks from China with our logos on them.
You got to love that.
Well, it's a ritual.
So as I go through here more, I'm talking about plaintiffs as a matter of conscience. There's that word again. Felt that it was not right to be compelled to participate with that as it violated their deeply held religious convictions. Additionally, plaintiffs had a right to refuse this treatment as it was only approved under the EUA, and federal law guarantees the right to refuse along with informed consent.
True.
No informed consent was ever given. We were told in no uncertain way that participation in the mask mandate was required and that no exemptions would be made on the basis of religious grounds. That is true.
Mm-hmm.
The only exemptions they gave were based off of medical stuff, but you had to have a doctor had to write you a note.
Mm-hmm.
And there were a lot of doctors that did. But that's beside the point. So I'm not going to go through all this other stuff here. I'll post this in the Telegram group. You guys are welcome to look at this. But as you get down here to my causes of action, here's my first claim for relief, the freedom of religion, the First Amendment. This is brought pursuant to the First Amendment under 42 U.S.C. 1983. Their actions injured plaintiffs in a way likely to chill a person of ordinary firmness, including plaintiffs and other students, from further participation in school activity. That is true.
Does that mean stop them to chill a person? Okay.
My kids, two of my kids didn't want to go to school because of this reason. And one of them actually stayed home her entire 8th grade year.
Can't blame them.
So their constitutionally protected freedom of religion motivated the school district's adverse actions. The school district defendants, by and through their employees, acted with a retaliatory intent or motive. So, again, this is how you lay this out.
Was that conclusory?
But this is in my causes of action.
Oh,
that's not a conclusory thing. That's an allegation. So a conclusory.
Oh, you can. That's right. You can allege something, right? Yeah, that's true.
And I'd say right here, and further allege.
And further allege. Okay.
I am alleging that their actions was with a retaliatory intent or motive.
Right.
Now, if I had said something that they, by and through their actions, they acted with a retaliatory intent, and as a result, my kids were
Discriminated
damaged for
against
life.
me.
Yeah, that's conclusory. Yep,
Well, it was traumatizing also. So there's a whole emotional aspect.
it was.
Um,
Here's one that I didn't include before: freedom of medical autonomy. I love that word.
the 14th Amendment, of course.
Yeah, the 14th Amendment. Oh, but wait a minute. The 14th Amendment doesn't apply to us because it made everybody a citizen of the corporation, and we don't have rights under citizen of the corporation. Wrong.
Well, I think if you're talking about the state national thing, I think then you can't claim these rights as a state national, can you?
Not that I'm aware of. I don't know. I mean, if you're going to go down that road, you can't. I don't get it. I mean, that's why I'm saying I would love to understand that, but I don't. And that's,
well, here's my thought. If someone comes in from another country and they're, say, here on a visa or living temporarily, what rights do they have in our country? It's probably a whole nother subject. Let's talk about that on a different one. But
yeah, we can.
Because I think that's kind of what it's doing. It's expatriating in a way.
Yeah.
No way. It's tying you to the land as an American citizen.
Okay.
So you're totally. Yeah.
Let's have a good
totally
talk about
to
that.
the Constitution.
I think we should write that down. Let's talk about that in more detail on another episode.
Okay.
But here, what I'm talking about is how, by forcing the plaintiffs to participate in undiagnosed medical procedures, that was the public policy from non-governmental agencies over their rights to medical autonomy. The defendant school district's violation of the right to medical autonomy was viewpoint-based in violation of the 14th Amendment. Right? Because that's what they threw in your face, wasn't it, Erica? Well, the CDC says this, or the WHO says this.
Yeah.
Well, I don't care. That's public policy. That has no place whatsoever in anything we're talking about. Okay? Equal protection under the law, under the 14th Amendment. Here's one that I love. This is one that I included that I did not have in my first one. Unconstitutional delegation of legislative power. Violation of the Utah Constitution, Article 4, Section 1, as to the mask mandate. This is what it says. Powers of the government of the state of Utah shall be divided into 3 distinct departments: legislative, executive, and judicial. And no person charged with the exercise of powers properly belonging to one of these departments shall exercise any functions appertaining to either of the others. Isn't that what they did here?
Yep.
Unconstitutional exercise of legislative power as to the public health order. Okay, and then I have my prayer for relief and my demand for a jury trial. Okay. Any questions on that?
There's a question right here.
Yeah. Department of Health or school boards, do they have a duty to do studies, review warnings and risks? Yeah, that's a great question. I imagine that there would be something in your state laws that might say that, but I don't know for certain.
I would say that anyone who was forcing the emergency use of any medical product or device had the responsibility of providing you with informed consent, as well as the ability to refuse or accept.
Which is the Nuremberg Code a long time ago.
Yeah.
Because that's what that whole thing was emergency use of all of that.
Mm-hmm.
Because it's not normal to wear a mask all day.
Yeah.
It's not. They only did that because they said that it was part of how they were mitigating the blah, blah, blah. So
exactly.
Right. And I think
they were forcing it.
I think the Nuremberg Code covers that. It's under any circumstance whatsoever. And emergencies don't null and void the constitutional rights, which is showing true because the courts are deeming these things unconstitutional. It's just that people have to take them, as James was talking about, case by case. They know how long it takes. They know most people don't have the dollars, which is why we're doing this, is to teach people to stand up to fight for yourself, because I don't think there's a statute of limitations on these things either.
No. When it comes to constitutional violations under 42, 1983, because this was one of the concerns Erica had,
Yeah.
There is no statute of limitations.
Right.
So
Learning it and standing up.
For other tort though, it's generally 2 years.
yeah, and that's
Or-
usually that varies from state to state. So check your state laws on that one. But in the federal court, no, there's no statute of limitations. So that's where I'm at. So for those of you wanting to know where I am in my case, we just filed. So the amended complaint, the one I just showed you, has not been technically filed yet. We filed a motion for leave to amend. The court directed us to do so, and the court directed that with our motion for leave to amend, we had to include our proposed amended complaint. So that's what I did. That was docketed and filed today. So where it is now, I'm the moving party now. I'm asking the court to grant my motion. The opposing party will more than likely file their opposition to it. They're going to state all sorts of garbage, why we should not be granted this. And I'm going to go back and say, hey, the court said we can do this and we should be able to do this. And the rules state that the court should freely give leave whenever justice so requires. So, and I think so too. And when you read that complaint, it's pretty straightforward. And I have stated a cause of action, and I have alleged a set of facts that are provable. So we should be good to go. So that's where we are.
That's awesome. So, okay.
So are there any other questions in the chat that we missed? I know we're running a little bit long. I always do this. I want to keep this to an hour, and here we are, an hour, 20 minutes later.
It's okay. I'll hold you to it on the next one.
Okay, please do.
Okay. We'll start out with so just so you know, I didn't tell you yet, James, but I'm going to add the steps to writing a lawsuit on our website, Affidavits 101.
Oh, perfect.
So you guys will have reference to that because that's how my brain works. Step 1, step 2, step 3. So
yeah, and that's an easy process for most people. I mean,
it is. So that'll be there too to help as a guideline type of template for you here shortly. Let's see here.
Comes from Section D of the 1986 No Liability to Vax Makers Act. I wonder.
Oh, yeah.
Oh, was that your original question on the Department of Health or school boards have a duty? Yeah, I would imagine so. So, at the end of the day, these masks were only approved, and you can find it. They were only approved under emergency use authorization. So, but everybody, and I mean everybody, said it doesn't matter. You have to wear it. Doesn't matter.
Yep.
You have to wear it.
Yep.
So everybody violated that.
And especially if you're a nurse.
Especially if you're a nurse.
Well, they're
still doing it today.
Still doing it.
I know.
This is what's ridiculous. You can't even walk into a hospital without them going, put a mask on. And and I'm just like, where I'm at now, I'm so done with it that thankfully I haven't had to go to the hospital. But if I did, I'd be like, hold that thought, please. And I'm going to pull out my phone. I'm going to call 911.
Mm-hmm.
I got somebody here trying to assault me.
Mm-hmm.
I need an officer down here right now.
Yep. Absolutely.
Okay?
Yeah.
They might change their tune there, right? So.
Yeah, absolutely.
Okay. Well, with that, everybody, I'm going to close it out. Any final thoughts, Erica, that you wanted to add?
Not really. I say the same thing every time. It's just, be brave, do your studying, and just a little bit every day, whatever you can get in. We all have super busy lives, and that's what they count on, is us being so stuck in the rat race that we stay ignorant of who we are and what we can do and what the law is. And so just study a little bit every day.
Yeah, you can do hard things. You guys are going to be just fine, but you can do hard things. So.
Yeah, absolutely. And if you feel like you want to do a workshop, Erica, while you're writing that lawsuit, and let people look on, do it online for the public out there. Let me know, and we'll set it up. Make sure James has time to tell you no. Don't do that. But like with no input, like your process, I think that would be helpful for people. Just this is what I'm doing, like they're looking over your shoulder.
Yeah, like thinking out loud. I really benefit from. That's how I taught when I was teaching for the university, because there are things that as an experienced nurse, you forget to say out loud why you just chose to do that particular thing to a baby nurse who's just learning how to do something. And It's a major concept, but you don't think to say it. I need
Yep.
that for me with the law. I need someone being like, okay, now that's why, so talking
Right,
it out
right.
loud is really helpful for me.
Well, let's ask. We've got some people watching. Do you guys feel like that would be a helpful thing? Literally, just watching someone type out their, while James course corrects and I make funny noises.
Where's your sound effects board?
I will not do one of those. Yeah.
You won't do the sound of
Yeah, I won't do one of those.
the audience
Sandboxer.
clapping.
Yeah, but if you guys feel like that kind of a workshop would be helpful, literally watching somebody do it, because Erica's got to do it. So
Yeah.
let us
And
know. We got 3 yeses. So okay.
All right, cool. All right, well, we can look at that down the road. Like I said, I'm up to my neck in these lawsuits I'm doing, and it's like every week goes by, and I'm like, oh great, here's something new I got to do. Here's something new I got to do. So, the last thing I wanted to end on, and I didn't want to forget about this, is I was listening to another gentleman who talks about, the law and such, and he brought up a very good point that just kind of made me go, huh. And he says, when you read the federal Constitution, the 6th Amendment talks about that's your rights in a criminal prosecution. It talks about how you have a right to assistance of counsel. And so what we've all been led to believe is that that's your right to an attorney.
Mm-hmm.
Is that what you guys would think, Erica and Justice?
Yeah.
Well,
not since knowing you, though.
Well, I know, but isn't it interesting to know that the American Bar Association was not formed until, well, let me ask you, when do you guys think it was formed?
The Bar Association?
Yeah. When do you think that organization came to be known as the American Bar Association? What year?
I would say when the new Constitution came into effect in the 1800s.
You're close. You're very close. Erica, what do you think?
I would say it seems like everything bad happened in 1913. So I'm going to guess that one.
Yeah, the lawyers had a lot to do with that. Justice was close. 1878.
I was going to say 79.
Yeah, 1878. So here's my question. If the founders put the assistance of counsel as one of your enumerated rights, what did they do before that?
You represented yourself.
Or but they said you have a right to assistance of counsel. So somebody else has a right to be there to help you.
Your mama,
your friend, somebody. Here's what's interesting is that the Constitution also guarantees your right to contract, and no court can interfere with that. Right?
That's true.
So let me show you a little something that he shared that I thought was brilliant. Every state has one of these. Let me know when you see the screen.
Okay.
Is it up yet?
Yep.
Okay.
You don't see it?
Yep.
Okay.
This is what you want to look for. Uniform Power of Attorney Act. What's a power of attorney? Erica? I'm sure you saw these a lot being a charge nurse.
Yeah, someone who has the authority to make decisions for you, either on your health or your legal situations, financial, whatever it's determined under. Yeah.
Given by the person.
Mm-hmm. Here's what's interesting. So this is here in Utah, under the Utah Uniform Power of Attorney Act. These are all the different things that a power of attorney can do. Look at this one right here. Claims and litigation. Unless the power of attorney provides otherwise.
So James, you're my power of attorney now.
Exactly. You can contract with someone and they can go into court. Right here it says they can assert and maintain before a court or administrative agency a claim for relief, cause of action, counterclaim, recoupment or defense, and these other things. So hold on a second though. Isn't that what an attorney is supposed to do?
Yes.
But it says right here, and this is effective 2016. It says right here that I can contract with someone else to do that. What am I missing?
I don't know.
The wool has been pulled over people's eyes.
Right, up until 2016.
On everything. Like,
Yeah.
This is what they did before the Bar Association is they had powers of attorney.
So why do you think that changed in 2016? Who became
It
president?
didn't change. That's just the law was updated in 2016. That law's been on the books for years. And I
So
guarantee every state's the same way.
So do we know what the updates were, like good updates or?
I have no idea. You can go back and look. I'm not sure. But every state's the same way. What it means is you can contract with someone else and they can walk into that court as if they were you.
That's
You
what I
can be
thought.
there. You don't have to be there. You can be there or not.
Right.
You're not there speaking for them. You're there as if you were them.
Right. That's
That's
what
the
I thought. That's when
Yep.
the representation, you can have
Yep.
somebody. I didn't think it had to be a lawyer, but good.
I know. And that's something I just learned today. And I'm like, oh my gosh, I don't know why I didn't think of that before.
Well,
That's
great.
brilliant. Because you can walk into a court. So like, for example, I could walk into a court. Let's say we had to have a court hearing on your case, Justice.
Right.
So rather than me sitting here trying to educate you
Right.
how to walk through it, we can walk into that court and I can hand the judge a copy of that power of attorney and says, yeah, Judge, I'm here to speak on behalf and for Justice and her husband.
Right. Awesome.
And there's nothing the judge can do.
That's great.
They can wind him up. Well, that's practicing law without a license. It's like, I beg to differ. We have a contract. This court cannot interfere with our right to contract.
You're not practicing law. You're
Nope.
making known available information to the court.
Exactly. So anyway, just a little something to hang your hat on. So here we are an hour and a half later. My
Okay.
goodness.
So, folks.
I know. So close. Next time.
Okay. All right.
Next time. All right.
Well-
Hey, everybody. Thank you so much. Erica, thank you for joining me again. Appreciate you. Justice, thank you for being on, for producing the show,
Absolutely.
doing all the behind the scenes things you do.
You're
I really
welcome.
appreciate that.
Thank you for all your help.
Thank
You're
you.
amazing.
With that, everybody, have a great weekend. Remember, you can do hard things. You can do this. We're here to help you, and we'll do everything we can. With that,
Absolutely.
peace. See you, everybody. Whew.
Huh.
We're still live.